Another victory for Project Veritas that I have the sneaking suspicion
CNN is not going to cover.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie back in the office to cover another vlog. Now, I talked about this story in one of my live streams from earlier this week, but I think it needs its own dedicated vlog because there is so much more to the backstory of this story that it needs its own detail, it needs its own highlights,
and it needs its own dedicated video.
The backstory to this is that one Shirley Teter sued Project Veritas, James O'Keefe, and others for defamation, unfair business practices, and other reasons. And you know what? No, we have to go even further back than that. To truly understand this story, we need to go all the way back to 2016, give or take, at a Trump rally where there was a certain act of alleged violence against a certain individual named Shirley Teter, who was 69 years old at the time, a very sympathetic victim at that, and this is what is alleged to have occurred at the time.
A 69-year-old woman says she was punched in the face after the rally ended.
Oh, I don't want to sound conceited, but I aged well.
69-year-old Shirley Teter is a fighter. She's fought back from a major surgery and fought for causes.
My whole life.
She protested for civil rights, against the Vietnam War, and now adds Donald Trump to her list. The piece teetered over to violence.
I said, you better learn to speak Russian. And I said, the first two words are going to be ha-ha. And he stopped in his tracks and he turned around and just cold-cocked me.
Police have a warrant out for Richard Campbell from South Carolina for assault on a female.
So that's what happened. You better arrest that son of a I think that's what I said.
As you can imagine, at the time, this story made the headlines, and rightfully so. I don't care about the pretext. I don't care about the alleged provocation. Someone assaulting a 69-year-old woman, that is a criminal act in and of itself, a newsworthy criminal act. But it seems that there might have been a little more to this story that Project Veritas, through its undercover reporting, found out, and this is what they reported at the time.
She was one of our activists.
She was one of your activists
who had been trained up to bird dogs.
Yes.
So the term bird dogging, you put people in the line at the front, which means they have to get there at 6 o'clock in the morning, so they're getting the front of the rally, so that when Trump comes down the rope line, they're the ones asking him the question in front of the reporters because they're pre-placed there. To funnel that kind of operation, you have to start back with people 2 weeks ahead of time and train them how to ask questions.
Right.
You have to train them to bird dog.
Project Veritas went undercover and got video footage of people admitting, people proudly boasting to working directly with the DNC, orchestrating these types of events at any Trump rally, getting these people who they referred to as bird dogs to get people provoked, to strike them, to do whatever, to cause a scene that can be reported by the media in order to demonize the Trump campaign.
The videos are from a conservative group famous and infamous for undercover work. More on them in a minute, but let's start with the content. There are 2 videos and 2 allegations against Democrats. The first, that operatives for the left, especially this man, Scott Fovel, have sent people to Trump rallies to incite violence. To an undercover operative, Fovel says there's a script.
It's a matter of showing up to want to get into the rally in a Planned Parenthood t-shirt. Or, you know, Trump is a Nazi. You know, you can message to draw them out and draw them to punch you.
Fovel is a Democratic consultant who recently worked with a group called Mobilize, hired by the Democratic Party in June.
They got undercover video footage of people admitting to having done this, making the connection to Shirley Teter, that she might have been the bird dog that one of these individuals was talking about in one of the undercover videos, and that itself, well, that was reported on by CNN, except this is how they reported on that.
Undercover videos produced by discredited conservative activist James O'Keefe suggest it was Democratic operatives, hired political activists, working in coordination with the DNC to instigate violence and incite reactions at Trump rallies. According to the undercover videos, it was this man the Democratic National Committee turned to organize the work. Bob Kramer is the husband of Illinois Congresswoman Jan Schakowsky. He's part of a group called Democracy Partners, and he too was caught on undercover video. Here explaining how he was hired by the Democratic National Committee to stage counter-demonstrations and press conferences wherever the Trump campaign showed up.
Wherever Trump and Pence are going to be, we have events.
Okay.
And we have a whole team across the country that does that. Both consultants and people from the Democratic Party and the everybody at Veritas and people from the campaign, the Clinton campaign. My role with the campaign is to manage all that.
Kramer stepped down from the campaign today and announced his subcontractor, Scott Fovel, was no longer working for his firm. In a statement, Kramer writes, "We regret the unprofessional and careless hypothetical conversations that were captured on hidden cameras of a regional contractor for our firm. He is no longer working with us." The Clinton campaign response, while Project Veritas has been known to offer misleading video out of context, some of the language and tactics referenced in the video are troubling, even as a theory or a proposal never executed. We support the Democratic National Committee's appropriate action addressing this matter and look forward to continue waging a campaign of ideas worthy of our democratic process.
Okay, so now you know a bit more of the backdrop here. You have Shirley Teter herself admitting to being something of a political activist, having participated in many protests in her life. You have these individuals purporting to work directly with the DNC, getting what they refer to as bird dogs, to go to protests, to provoke people to assault them so they can use it for political purposes. Well, Shirley Teter didn't much like this reporting, so she decided to sue Project Veritas for defamation and other reasons. She also sued the guy who allegedly assaulted her, Campbell, and they had their own litigation between them, which subsequently settled, but she sued Project Veritas. Her lawsuit was dismissed on a directed verdict, and if you don't know what a directed verdict is, I refer you to old Viva, who is a very awkward and cringeworthy Viva. Watch this. And in arriving at the decision to dismiss the defamation lawsuit, the judge came to the conclusion that no evidence had been adduced proving malice. Malice being a criteria that is necessary in order to succeed on a claim of defamation when the petitioning party, the claimant, the plaintiff, is a public figure. And from what I understand, Shirley Teter in this case was deemed to be a public figure to the point where in order for her to succeed on her claim, she had to prove the actual malice of Project Veritas and James O'Keefe in their coverage of her. The judge said no evidence has been made to that effect. We're not even going to give this to the jury to give them the opportunity to make a mistake on a judgment when evidence of the essential elements has not been adduced. Shirley Teter not only had her lawsuit against Project Veritas dismissed by way of directed verdict, but the judge who dismissed her lawsuit also ordered her to pay Project Veritas costs, and when Project Veritas sent the bill of costs to Shirley Teter, she said, "I don't have the money to pay her costs," and asked the court to dispense her of the obligation to pay Project Veritas costs for her failed lawsuit. A clerk of the court actually initially dispensed Shirley Teter of paying the costs that the judge originally ordered her to pay, and Project Veritas obviously did not like that decision and appealed that decision to a judge, and that is what we are going to read. Highlights from the decision ordering Shirley Teter to pay the costs of Project Veritas, because talk about adding insult to injury. What the judge says about Shirley Teter in this decision, it's a judicially polite way of calling her a liar. In the United States District Court for the Western District of North Carolina, Asheville Division, Shirley Teter plaintiff versus Project Veritas Action Fund, Project Veritas, and James O'Keefe III defendants. Memorandum of Decision and Order. This matter is before the court on the defendant's motion to review clerk's order denying costs. Background. The present action is one of two actions filed in this court arising from an incident that occurred between the plaintiff Shirley Teter, plaintiff, and Richard Lamar Campbell outside of a political rally in Asheville, North Carolina on September 12, 2016. On September 14, 2017, the plaintiff initiated the present action asserting claims for defamation, libel, slander, and unfair and deceptive trade practices against defendants Project Veritas Action Fund, Project Veritas, and James O'Keefe III, arising from their publication and dissemination of videos related to the incident between Campbell and the plaintiff and of a political operative purportedly commenting thereon. In the companion case, Mr. Campbell asserted claims against the plaintiff of assault and battery, malicious prosecution, and defamation, and the plaintiff in turn asserted counterclaims for assault and battery, defamation, libel, and slander against Mr. Campbell. The two cases were consolidated for the purposes of conducting discovery. 5 of the 6 attorneys who currently represent or previously represented the plaintiff in this action also represented the plaintiff in the companion case against Mr. Campbell. To simplify this somewhat complicated procedural background, not only did Shirley Teter sue Project Veritas et al., but Campbell, the individual that Shirley Teter alleged assaulted her, sued her, she countersued him, and they ultimately entered into a confidential settlement agreement between the two of them in what is referred to as the companion case. We will get back to this confidential settlement between Campbell and Teter a little later on, but one of the major things to take away here is that she had 5 of 6 attorneys representing her in that companion case, which means that that she had 6 attorneys representing her in this case, 6 attorneys for someone who now claims to be unable to pay the costs owed to Project Veritas. It doesn't take much to put 2 and 2 together, or in this case, 6 and 1 together, 6 attorneys and 1 plaintiff together, to know that
This does not make a lick of sense.
But then getting back to this case and how it ended, it actually went to a jury trial, but before there could be a verdict, the judge, after hearing all of the evidence, dismissed the case as a pure matter of law. In the present case, the court entered an order granting summary judgment in favor of the defendants on the plaintiff's claim for unfair and deceptive trade practices, and the parties proceeded to a jury trial on the plaintiff's remaining claims for defamation, libel, and slander. Following the close of evidence, the court determined that the defendants were entitled to judgment as a matter of law on the plaintiff's claims for defamation, libel, and slander. Thus, on June 7, 2019, the court entered a judgment dismissing the plaintiff's action and including a provision that, quote, the defendants shall recover their costs of the action from the plaintiff, end quote. The defendants, Project Veritas et al., then filed what is known as a bill of costs, and it is exactly what it sounds like. It's a bill detailing the judicial costs that the defendant thinks are owed to it by the plaintiff. They send it to the plaintiff. It's in the amount of $23,900 and change. The plaintiff says, I don't have the money to pay it, and also you included certain amounts in there that are not owing to you. So the defendants then went and revised their bill of costs to reduce it to slightly over $23,000, and the plaintiff, Shirley Teter, says the same thing. I don't have the money to pay it, and I don't think you included proper things in your bill of costs. And by proper things, I mean that the plaintiff is alleging that the defendants have included certain costs that they are not entitled to recovery of in their bill of costs. We'll get to that later. It's a detail, but the bottom line, Shirley Teter says, I don't have the money to pay the bill of costs that the court ordered me to pay. That is what Shirley Teter initially argued before the clerk, who actually granted that argument and said, okay, we are dispensing Shirley Teter of paying the costs that the judge ordered her to pay. Project Veritas sort of appeals that decision. They're going in front of a judge now, and the standard of review in cases like this is de novo. The judge owes no deference to the clerk's decision. They just start anew, and the judge comes to his or her own decision regardless of what the clerk had initially decided. Project Veritas' principal argument is that the plaintiff, Shirley Teter, has failed to establish that she is in fact unable to pay the costs owed by her to Project Veritas, despite what she said in her affidavit. The plaintiff contends that she is unable to pay the costs at issue, and this was the basis for the clerk's determination, to which the defendants now object. In support of her argument, the plaintiff has submitted her bank records from January through December of 2019 and an affidavit signed by the plaintiff in August of 2019 detailing her monthly income and expenses. In her affidavit, the plaintiff states, I have no money to pay for defendants' litigation costs. I had or have no money to pay my lawyers the costs and expenses they incurred on my behalf in representing me. My lawyers did not agree to pay the costs and expenses they incurred on my behalf, and they certainly did not agree to pay any award of costs incurred by defendants. Well, it's all fine and dandy that Shirley Teter says in an affidavit that she doesn't have the money to pay the costs that the court ordered her to pay for her failed lawsuit, but there is that pesky thing of that settlement between her and Campbell in the companion case. While the plaintiff attests in her affidavit to having no funds with which to pay the defendant's costs or the costs incurred by her own attorneys, upon questioning at the February 25, 2022 hearing, plaintiff's counsel acknowledged that the plaintiff received a substantial payment from Mr. Campbell in January of 2019 as settlement in the companion case. Plaintiff's counsel further explained that half of these settlement funds were used to pay the plaintiff's attorneys, some of whom represented the plaintiff both in this case and in that companion case. You swear in an affidavit to the court that you don't have the money to pay the court costs, and yet your attorneys confirm that you received a substantial settlement payment from Campbell in the companion case. Okay, that makes a lot of sense. And the judge, picking up on this apparent inconsistency in Shirley Teter's story, concludes as follows. Therefore, when the plaintiff submitted a sworn affidavit to this court that she, quote, had no money to pay my lawyers the costs and expenses they incurred on my behalf, end quote, she was less than fully candid with the court. That is the most polite way on earth for one person to call another person a bald-faced liar. And the judge doesn't stop there. The judge then goes on to rightly question how an individual with no money to pay their attorneys has 6 attorneys on file representing her. However, the plaintiff's receipt of a substantial sum in the Campbell settlement also does not fully explain the plaintiff's financial arrangement with plaintiff's counsel. The plaintiff was represented by 6 attorneys in this matter, all of whom were from outside of this district, and one of whom was from out of state. 4 of these attorneys were present for the entire trial. The plaintiff had the sort of representation not ordinarily available to litigants in her position. In the court's experience, there are only a few scenarios where multiple out-of-town attorneys would be willing to become involved in representing a plaintiff who, by all accounts, is indigent and therefore cannot pay the costs of the litigation herself. Going back to the undercover reporting by Project Veritas that we looked at the beginning of this vlog, some people might come to the conclusion that it's possible, it just might be somewhat possible, that 6 attorneys representing Shirley Teter, a woman who some people in undercover footage admitted might have been a political operative bird dog, it's possible that there might be some politics involved and that other people might be paying these 6 attorneys to represent Shirley Teter, an alleged bird dog. But if you had that thought, you must be one of those out there theorists, and don't worry anyhow, because Mr. Sasser, one of the attorneys in the file, unsolicited said no, Hillary Clinton and the Democratic Party have nothing to do with paying the legal bills in this case. Mr. Sasser did not explain, however, why 6 out-of-town attorneys would agree to take Ms. Teter's case on a, quote, primarily pro bono, end quote, basis. Moreover, Mr. Sasser did not explain why, once the Campbell matter was settled, that these attorneys continued to represent the plaintiff on a contingent fee basis. After all, the plaintiff's claim was so weak that it did not survive a motion to dismiss at the close of the evidence. Further, Mr. Sasser only raised more questions by his unsolicited statement, specifically disclaiming that the lawsuit was being funded by the Clinton campaign or the Democratic Party. That was not the question that the court asked. However, Mr. Sasser's rush to assure the court that certain political organizations are not involved begs the question of whether some other organization was involved. Yeah, I think Shakespeare said it best when he said,
"Methinks he doth protest too much."
The court ultimately orders plaintiff Shirley Teter to pay the litigation costs incurred by Project Veritas, although the court reduces the amount from $23,000 and change to $15,000 and change by excluding certain items that the court determined ought not be included in the bill of costs. For all these reasons, the court finds that awarding costs to the defendants is appropriate in this case. The expenses that may be taxed as costs under Rule 54D1 are set forth in 28 U.S.C. Section 1920 as follows, and you can pause and look those over at your leisure if you're curious. It is therefore ordered that the defendant's motion to review clerk's order denying costs is granted in part, the clerk's order regarding taxation of costs is vacated, and the clerk of this court is instructed to assess costs against the plaintiff and in favor of the defendants Project Veritas Action Fund, Project Veritas, and James O'Keefe III in the amount of $15,920.52. So that is the judgment, and it really highlights something I have said many times on this channel. Litigation is a two-way street. You don't just get to sue people with impunity. Sometimes when you sue, you're going to lose, you're going to get ordered to pay costs, and in this case, Shirley Teter lost. Now she's got to pay Project Veritas' costs, and I'm making 2 predictions. One is that the mainstream media is not going to cover this story, and if they do, they are going to spin it as though it was a loss for Project Veritas.
Project Veritas claimed $23,000 in costs, and they were only awarded $15,000 in costs.
And my other prediction is that what Mr. Sasser said, what he denied in court, probably is more true than it is not true, and we are going to find out that there were, in fact, distinct ties between the Democratic Party and this alleged bird dogger, Shirley Teter. And with that said, if you like my videos, you like my content, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of these support links are in the pinned comment. We've got merch. If you want to support Robert Barnes and I, you can go to Locals, where you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, where you can find a neat little widget that will bring you to our Locals community. But more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.
But she's an old lady. I mean, look at her. She's old. You can't just take her stuff. She's too old.